Testing Justice 7. Testing Justice 6.
Thank you.
Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing Justice 1.
Set up yet.
Presenting anything new before the Honorable Justices of the Supreme Judicial Court, sitting in the Law Court at Portland within the state of Maine, may come forth and declare, and they shall be heard.
Good morning. You can be seated. The first matter before the court is Cumberland 24-407, State of Maine versus Christopher DeRoche. We are being streamed live on the web, both by audio and with video. If counsel would identify yourselves by saying your names for the record, together with the party you represent.
Tyler Smith for Christopher DeRoche.
Christopher Coleman for the state of Maine.
Thank you. And counsel, if you're ready, we'd be happy to hear your argument, starting with the attorneys.
Thank you. Good morning, and may it please the court. State v. Goncliffs, In re Blasdell, Narrowitz versus Board of Dental Practice. These are three cases that the court may not have expected me to bring up when I first came up here, but they all deal with a very important point that goes to the heart of what this case is about. The public's confidence in the integrity of judicial proceedings, and that's what this case deals with. This case deals with two errors, both of which are preserved. The first one is that the trial court denied Mr. DeRoche his right under the statute to have his attorney question prospective jurors. As acknowledged by Representative Damon on the House floor in the face of calls to repeal that statute, Section 1258A is about protecting the person who's standing in the courtroom facing criminal charges. So it's hard to imagine a situation that may be more challenging to public confidence in a particular proceeding where the trial court declines to apply a statute that is intended to benefit the person who is facing criminal charges. And that's especially so in a case like this. This is a case involving an alleged sexual assault of a minor. It's purely natural that jurors in such a case would expect to hear from the defendant. And for that reason, voir dire is especially important. And instead of trial counsel being able to directly address the jurors, ask them questions, and then gauge their responses based on their firsthand, person-to-person interaction, we have 14 lines in the transcript in which the trial judge told the jury, about the prospective jurors, about the burden of proof, the presumption of innocence, and then the right to remain silent, and then asked the jury if anybody would be reluctant or unwilling to imply any of those basic principles. The second issue is that the state was impermissibly allowed to argue and present testimony suggesting that Mr. DeRoche had a burden of proof, that he had the burden to give the jury some reason to think that the alleged victim had a motive to lie. And this is really a situation where we need to apply some common sense. The prosecutor argued in closing arguments that there's been absolutely no evidence introduced suggesting that the alleged victim had a motive to lie. Evidence is introduced by parties, and there are only two parties in the courtroom. So who would the jury think that the prosecutor is referring to? And what's worse is because this is a preserved error, when trial counsel objected, the trial judge overruled that objection, which sends the message to the jury that the prosecutor's point was a fair one.
I see the green light is on. Can we go to your first argument? And perhaps I'm oversimplifying here, but I understand your emphasis to be upon the fact that the statute appears to be an absolute. And the issue, I think, turns on the language, the court shall permit voir dire, under its direction, under its direction. I'm wondering what that means. If this is an absolute statute, are you arguing to us that the defense attorney can say to the judge, okay, judge, voir dire, we've got it, let us know if you got anything going on here, and just take it over from that point going forward, with the judge having no idea what's going to be asked or only trying to correct errors after the fact? Is that what you're arguing here today?
No, it's not, Your Honor. Our position is that under its direction is supervisory language that allows the judge to control the scope, prevent harassment, and maintain efficiency.
Okay, so we're on the same page. Let's drill down on that. In order to do that, doesn't the judge have to know ahead of time what the lawyer's going to do, what questions they're going to ask? How can the court possibly direct voir dire by counsel not knowing what's coming?
Well, I think it would have been appropriate for the judge to indicate that for the court to properly entertain the request, it needed to know what the scope of the questioning would be.
But in
And
this
that's
case-
not what happened in this case, because
But
the
that's
judge
what happened.
the judge asked what the areas would, if counsel could share the individual questions.
Right.
Counsel said that they were reluctant to do
So
that
we
at that
prefer
point.
not to. And
Or
the judge
prefer
didn't-
not to.
The judge didn't pursue it further. Neither did counsel.
And that's exactly the point.
Is that even required, or is it sufficient to simply say, I want the right to conduct voir dire? And in this case, the judge said, well, I think Rule 24 says I don't have to let you, period.
Well, that goes really to what my answer was going to be, but perhaps stated a bit more eloquently. Really, the fundamental problem, in my view, on the waiver argument, which is what I think Justice Mead's question may be getting at, is that trial counsel was not directed to share his questions, and he was not directed to share the scope or topic areas.
But
that he
isn't the real
questioned.
problem here, that let's assume I agree with you, okay? That it was error for the judge to just say out of hand, sorry, I'm not going to let you, despite the language of the statute. Let's assume I agree. The purpose of voir dire is to impanel an impartial jury that will be fair. How do you identify prejudice in this record? There were no requests for any specific voir dire given, whether at that point in the conversation or later when the judge invited written requests, or for that matter, any objections during the voir dire process or suggestions for additional questions. We don't have any of that on this record. We have, would you agree there's nothing in the record to show impartiality or lack of partiality in fact in this jury?
I would agree with that. There's no
Okay.
specific evidence showing partiality, but no system is perfect. And here, the right that's been denied is one that is designed to detect prejudice. So it's really a question of how do we prove what we don't know. The other issue that
Well,
this
then aren't you
links
really
back.
arguing that it has to be structural? I mean, the only time we do that without any actual prejudice shown in the record would be if it were structural error.
Well, no, I disagree, Your Honor, because Mr. DeRoche was denied of basically a qualitative tool to allow him not only to detect prejudice, but also in order to intelligently exercise his peremptory challenges based on personal interaction with the jurors.
But you have
under Section 12.
no record evidence of how it prejudiced him, so you're saying you don't need it, so you're saying it's structural.
Well, I'm not saying it's structural, Your Honor. What I'm saying is he had a right to have his attorney personally question the jurors, allowing him to make informed peremptory challenges, which is...
But you're not indicating how, in this instance, the lack of that ability prejudiced him, except it stripped him of a right that you say he had, which is a structural claim.
Right. And if that's the rule, Your Honor, that gets back to the public confidence issue where we have a trial court
But how
that
can you have a structural error if you're focused on the statute and not the Constitution? You're not saying this is a constitutional violation, correct?
Right. I'm not saying it's constitutional. It's a statutory
Correct.
issue. But as far as harmless error, first of all, with harmless error, where it's a preserved issue, the state has the burden of persuasion on that issue of showing that the error was in fact harmless. And like I said, there are two components to that. It's not only the issue of whether the jury was prejudiced, but also whether Mr. DeRoche was denied of an opportunity to exercise his peremptory challenges intelligently based on...
But there's not actually, again, a constitutional right or anything else to peremptory challenges. I mean, that's a creature of the procedure.
No, I agree with that, Your Honor. But what it
In
shows,
fact, maybe we should get rid of them.
well, that would be an issue for the Rules Committee, I suppose.
Well, counsel, if this is purely a statutory issue, what do you make of the interplay with Title IV, Section 9, which basically says the court has the authority to issue rules, and after the effective date of said rules, all laws in conflict shall be of no force and effect? And don't we have a don't we have an ambiguity within the statutes themselves?
And I addressed that tension in the blue brief, and the way that I view that is you have Section 9, which reads as Your Honor indicated, but then you also have Section 1258, which contains its own conflict of law provisions, saying notwithstanding any
Yeah,
rules
they
or
sort of cancel
statutes
each
to the
other out, don't
contrary.
they? They sort of cancel each other out. Another question, if Rule 24A said instead of the court in its discretion may allow, if it said the court in its discretion, the court shall allow, under appropriate supervision or direction, the parties or their attorneys to address additional questions to their prospective jurors, would that satisfy the statute, do you think? In other words,
I think
Rule 24A says the court shall conduct the initial examination. Suppose that then went on to say, but then it shall allow the attorneys under its direction.
That would be consistent with my reading of Section 1258. And I just do want to make sure I make the point clear in terms of Your Honor's earlier question. I don't think Section 9 and 1258 cancel each other out. My view on that is that Section 1258 is a more specific statute.
That's one of the rules of statutory construction when you have two seemingly conflicting statutes. The other one is you look at the latest one that was enacted and you say that one applies, and that would be for Section 9, wouldn't it?
That is true. That's another rule of statutory construction, and then you get into issues of legislative intent, and in this case, we have a very
Can I,
thorough...
in the 1 minute you have left, can I take you to your other point?
Absolutely.
We do have a raft of cases that say that commenting on the evidence, what is there is appropriate, and that no inference can be drawn from stuff that's not there. And I notice in your brief you say, here, the prosecutor's use of the past participle introduced is one of the key factors here. By saying introduced, are you saying that is the word that triggered the inference that the defendant had to introduce?
I am. I think when prosecutors begin talking about lack of motive, they are getting dangerously close to a situation where there could be a burden shifting and need to be very careful about the language.
Counsel isn't...
I was just going to say, so if the word introduced was not in that sentence, would it be a different scenario?
I think it'd be a much weaker argument if I did not have the word introduced. And I think one factor that makes this argument much stronger is that we had an objection in front of the jury, and the judge overruled that objection, sending the message to the jury that the prosecutor's point that somebody failed to introduce evidence of a motive to lie is a fair point.
Thank you, counsel. You'll have a rebuttal argument as well. Attorney Coleman.
Thank you, Madam Chief Justice. Good morning, Madam Chief Justice and honorable jurists of the law court. May it please the court, my name is Chris Coleman, and as a representative of the state, I wanted to address a few things cited in appellant's gray brief, specifically the legislative history he cites. It's true that Article 1, Section 7 of the Maine Constitution empowers the legislature to create a system for jury selection, but with great constitutional power, there also comes great constitutional responsibility. The words of Article 1, Section 7 itself mandate that the system ought to be suitable and impartial. Furthermore, as with any legislation, it must live within the legal ecosystem created by the Maine Constitution as a whole. A law which treads upon the judicial power, a power which is explicitly bestowed upon this court by Article 6, Section 1 of the Maine Constitution, must be read with a presumption of constitutional intent. This court has interpreted that judicial power to allow it to regulate that which is essential to its functioning as a court. Nothing is more essential than control of the courtroom and the responsibility to ensure that this court is a fair tribunal, that the trial court is. So the legislature had the right to pass a law concerning voir dire, and the legislative history cited by the appellant simply demonstrates that they did that. However, as this court has made clear in subsequent decisions like Bernier, Bowman, Rollerson, and Rancourt, there are constitutional limits to the legislature's power. If a trial judge has a non-arbitrary reason for disallowing attorney-led voir dire, they may disallow it. The ability to control the courtroom remains within the judicial power and can't be infringed completely by the legislature. I also want to take a moment to comment about legislative intent. According to this court, if the plain meaning of the text does not resolve an interpretive issue raised, then you consider the statute's history, as cited in the gray brief. Also, though, underlying policy and other extrinsic factors to ascertain legislative intent. This court may apply independent judgment to questions of statutory interpretation and adopt a rule of law that is most persuasive in light of precedent, legislative history, reason, and policy. That includes the interpretive canon of constitutional avoidance discussed in the appellee's brief. This is to say that this court can and should read 1258A in a way that presumes the legislature did not intend to conflict with the judicial power. While the actual intent of individual legislators is important, your rules of interpretation allow for, and in some cases demand, a presumed intent that is not necessarily reflected in the black letter of legislative history. The legislative intent behind any given statute is thus a legal construction, not a question of fact. The case law of this court reflects that. That's why it's a question for de novo review. The legislative history is important, but the question of legislative intent doesn't necessarily have a historical or empirical answer. It's a question of law. Now, concerning the second argument, I want to
See, the green light is, whoa.
That was dramatic.
That was dramatic. I see the green light is on, is what I was about to say. And I want to stay on this first issue.
Sure.
Are you suggesting, in this case, the judge basically said out of hand when defense counsel said, I'd like the right to conduct attorney-led voir dire, the judge said, I don't have to let you, period. Basically, that's what he said.
He articulated two bases for his ruling
Said,
on
I've
the
had
record.
experience with it, I don't like it.
That's true, and I would point to the Bernier decision. So in the Bernier decision, the judge in that case said, there's nothing special about this case. This is a run-of-the-mill
I
case.
understand, but my question to you is that an error, putting aside the issue of whether there's prejudice, and obviously that's a significant issue here, but isn't that an error to say, out of hand, I will not permit attorney-led voir dire?
I guess I have a more charitable reading of what I think the trial justice meant when he said those things. I agree it would be error to deliberately ignore any statute passed by the legislature for no
When you talk
reason.
about judicial power, I mean, that is preserved, is it not, in the statute when it is subject to the court's direction?
Precisely.
And section, Article 1, Section 7, by specifically allocating to the legislature to provide a suitable and impartial mode of selecting juries. Doesn't that tell us, in the conflict between Title 4, Section 9, and Section 1258A, doesn't that really tell us what is the right answer, that 1258A is still good law?
I agree that 1258A is still good law,
Okay.
certainly.
And
I think,
control.
but it needs to be read in a way that can live in, like I say, the legal ecosystem created by other provisions of the Maine Constitution. Let's say, for example, that 1258A had some language that somehow infringed upon the Equal Protection Clause. Let's say they set up a separate system of voir dire for people of different genders or something like that. Obviously, it's got to live in the ecosystem created by
Well,
these
it
other
does.
provisions of the Constitution.
But in this case, the counsel was told essentially that they would not be permitted to ask questions.
Well, I think that's because the analysis is that the questions need to be part and parcel of whether they are reasonable to be asked or
If
not.
this was a flat no position from the Superior Court, then it wouldn't have asked the lawyer, what questions do you want to ask?
Precisely, Your Honor. And I think he was really clear, and if you look at the appendix provided in the record, that performed a second basis for his ruling. So he made it clear that that was the reason that he denied
How would one
this.
show prejudice in a situation like this? Just spin it out. Is it a matter of what question, of proposing questions that weren't asked, of asking at the time of voir dire, for example, judge-led voir dire, to say, Judge, I want to follow up on that myself? I mean, what does it take to, assuming that it's not prejudice automatically, to say no?
I mean, I think that The example that you cited is probably the way for defense counsel to proceed. For the state, with the harmless error analysis and the burden being mine, I think I would just say that in a case where we have to prove a negative like this, that there was no prejudice, the absence of evidence is actually evidence of absence.
Well, one way to show prejudice would be to look at the entire context of the voir dire. Now, Attorney Smith suggested that the court asked 4 or 5 questions here. Suppose there were just one question asked and no other questions. And I suspect here, although I didn't ask Attorney Smith, usually in these kinds of cases there are questionnaires, and jurors respond in detail or at length to questions. Wouldn't that entire context be looked at to determine if there was prejudice?
I agree, and thank you for that, Justice Douglas. I think one thing that I learned responding to the amicus brief is that the literature on this subject delineates not 2, but 3 types of voir dire. There's attorney-led voir dire, there's judge-led voir dire, and then there's sort of questionnaire-led voir dire, clerk-led voir dire. So when I talk about the social science of like a charismatic interviewer effect, things like that, the social science cited by the amicus brief and their intimidation potentially by one of the jurists, that is eliminated with the voir dire conducted through questionnaires. And I think the social science says, and part of what the trial justice in this case said was he felt that was a significant protection that safeguarded against those kinds of prejudices.
I'd like to focus on the legal impact of the lawyer indicating that he would prefer not to identify his questions. You say that that's waiver. Now, waiver in the ordinary sense is a conscious relinquishment, a voluntary relinquishment of a known right. And it doesn't sound like waiver. It sounds more like a question of whether it's an abuse somehow of the judge to take that into consideration and say it's an abuse if you say, I don't want to answer the question, that it's more of the merits as opposed to a waiver. Are you still sticking with that waiver argument?
I do think that there's something to the waiver argument, Your Honor, just because the case law is so clear that a right can be waived by actions, and it can be judged by the totality of the circumstances. I think that the sort of obstinate...
If he thinks he has a right to ask these questions, then it's the opposite of waiver, isn't it?
But what questions, right?
Well, isn't that the question that we are trying to answer here? What does it mean when the statute says under the court's direction? So their position is I don't want to speak for Mr. DeRoche, but one argument could be we have an absolute right. We don't really have to identify to the court in advance. So it's not really a waiver so much as a question now of what the statute requires.
To say that doesn't mean the judge can't jump in if as one of my colleagues once said, when the question starts being, what's your passion in life? And the judge can jump in. And the case law, we've made that clear.
Right. My position is it's not an absolute right. I don't think that it is.
What do you think the minimum is that the statute requires? What does the trial judge have to allow in your view?
I think that the trial judge needs to solicit questions from both parties to give them the opportunity to. I think that the questions themselves are part and parcel of the analysis for the trial judge about whether it's most appropriate for them to be asked by the judge themselves via some type of questionnaire or by one of the parties. And so they need to know the text of those questions. That's part of the just bare minimum showing for the judge to make that analysis.
As a policy matter, are you opposed to lawyer voir dire?
No, frankly, I'm not. And I think that if this is not an issue which cuts for or against the defense bar or the prosecution, I think that state prosecutors will rise to the challenge of that is something that is more commonly done in the state. And I think it is creeping into our jurisprudence or our practice more and more. I'm not afraid of doing that kind of stuff, but I do think that there are logistical issues faced by the court right now that I see daily in my practice.
Is it appropriate for the judge to ask in each instance, okay, you can have individual, or you can have lawyer-led voir dire, but I want to know what you're going to ask. What are you going to be doing? Is that a mandatory
I think so.
process?
I think it is, Your Honor. I think that's an essential part of it. And if you look at how other states have developed this, I was really happy to have a chance to respond to, again, in the amicus brief, they cited the Massachusetts judge. And I was able to show that there's a whole system in Massachusetts with very specific rules about how this is done. And I just think that if this is going to be something that we are allowing or mandating in every case, there should be a robust set of rules like that.
Isn't this really a matter of, even though we can all agree, like I say, that we don't necessarily want to see, and I don't think the statute gives a right to unfettered attorney-led voir dire, it's a question of where essentially the burden lies, isn't it? In other words, do you give, does the statute confer a right to attorney-led voir dire that the judge can cut off if it leads astray, is not really targeted to ferret out prejudice in the jury, versus whether the judge has to have a showing, if you will, that there's a reason to allow attorney voir dire.
So I think that distinction collapses in that they can cut it off initially if the questions are just patently inappropriate.
Well, the
Sure.
problem is you're spoiling the pool, right? If somebody asks a question and everybody's got to go if they hear that question.
Yeah, exactly.
You alluded to some logistical issues or that you see cropping up that might impact this discussion. What were you referring to?
So, my concern are cases like the, Rancourt case, essentially, and that in that matter, it took them a day and a half to voir dire 8 jurors. I think that jurist was a saint, and they certainly took the time to do that. And
But we can all agree that a jurist doesn't have to allow that. even
no,
under the
certainly, and
statute.
well, that's apparently up to what will be decided here today. But my position is that abuses like that will still be out there, and it will be incumbent on trial courts to limit the Rancourts of this world. And with ever fewer judicial resources, that's ever more important.
Are you saying those abuses will still be out there, or are you saying they'll be increased?
I think
To the
that,
extent that we're moving towards.
yeah, I think that there's more opportunities for them to occur, and I think that if this system were ushered in without the kind of comprehensive rules that Massachusetts has and really clear guidance for litigants, you would see more Rancourts. The one study that I cite in my response to the appellate brief says 80% of voir dire time is spent impermissibly indoctrinating the jury. So, there's some trade-offs there.
There are states that allow wide open voir dire. Some have it, the judge isn't present, and it does create a scenario where, as you say, lawyers can create a rapport with jurors and kind of do a test run on the facts as they state them, and I don't think anybody wants to go there.
Right, and that's just that the parties both have a right to an impartial jury, not a jury which has been primed to a specific defense or a specific offense. It's an impartial jury that we're looking for. And I think that that's really what voir dire needs to be focused on, not showcasing somebody's personality or defense.
Thank you.
Okay.
Attorney Smith, isn't that the fear? Isn't that the boogeyman in the room? We've all, I'm an old plaintiff's lawyer from many years ago. We were all told that, you can win your case in voir dire if you choose to do so. And really, that's not necessarily appropriate in the sense of going to the impartiality of a jury, is it?
I agree, and that's what the language under its direction allows. Just like in the Rancourt case where trial counsel was crossing the line and the judge shut trial counsel down.
So we have said already, I'm quoting Bernier, there's no indication in the record that the jurors in this case were biased or that the defendant was unfairly prevented from asking specific questions that might have revealed potential prejudice. So therefore, if there's error in not following the statute, it was harmless. The mere circumstance of having questions put to the jurors by the presiding justice instead of counsel does not without more constitute prejudicial error warranting reversal of the judgment of conviction. Isn't that exactly the problem here?
Well, I think the Bernier case, for one, had minimal, or if I recall correctly, perhaps no discussion of Section 1258 specifically.
I don't think that's accurate, but go ahead.
But then in addition to that, getting back to the issue of structural error, one thought that occurred to me as I was listening to the questions from the bench is that Article 1, Section 7 does indicate that the legislature is the body that enacts the procedure for conducting voir dire. And in this case, the legislature has done that. It's enacted a statute that commands that trial courts shall allow voir dire to be conducted by the attorneys. And in this case, that framework was violated. I understand why the
But it says
trial court-
under its direction. It's not an absolute. It's under its direction, right?
And that gets
And
back
so
to
the court says, I'm going to allow attorneys to, I'm going to allow you, counsel, to ask questions. We'll do it. I'll do the usual, general questionnaires, and then we'll have people come up to the bench, and if you have specific questions, follow-up questions on a for-cause challenge, you can ask them. Isn't that allowing counsel to participate and ask questions?
The floor under the statute is that counsel needs to be allowed to ask questions of prospective jurors. The process that Your Honor just identified only allows questions of individual specific jurors from the larger pool who are called up individually.
Well, the
So I
statute
think
says
that's-
shall conduct, permit voir dire examination. That's pretty general. That's not specific. Doesn't mean everybody, right?
Well, the prospective jurors, Your Honor, are the people who are in consideration for becoming the jurors. So there needs to be some mechanism where trial counsel is allowed to pose questions to each person who is potentially going to be on the jury pool, similar to what you do in civil cases under the new rule, where there's a smaller group of people from whom the final peremptories will be addressed.
Thank you. Thank you, counsel. As is our usual practice, we'll be taking this matter under advisement and issuing a written decision in due course. With that, we'll be in recess on this matter.
those things, lawyers can instead offer otherwise inadmissible evidence. And that offends two...
Counsel, I know that the green light is on.
It is.
Was there an actual order or a ruling ahead of trial that information about the no contact provisions could not be introduced? I understand it's something that maybe everybody understands, but...
In the, I think this is a kind of a unique case because there were two trials. In the first trial, it was something the prosecutor actually said, I acknowledge that the bail status, we shouldn't go into the bail status. There, it was brought up accidentally. There was a motion for a mistrial. In that case, there was a curative instruction offered by the court. So I think it was just understood by everyone. Certainly that's the impression that I have. And this problem with the door opening principle is that it, as I said, offends two principles that this court talks about quite a bit. First, it's an avenue around the rules of evidence and procedure. It's a way to actually inject prejudice into a case. Second, it offends...
But isn't it also serve the purpose of it's a deterrent for counsel from one side or the other to put something in that they want to get in, but it might blow up if, and it's by itself, it needs explanation, and it could blow up and expose other matters. So doesn't it serve a valuable deterrence factor?
It didn't in this case, I don't think. So I'm not sure, hypothetically, probably. I'm never going to say no to anything like that, but it didn't in this case. And I don't think those were the circumstances here. But the second principle this offends is the notion that attorneys' tactical and strategic choices bind their clients. When you choose not to object or to exclude or to limit, you don't then get to turn around and complain you were prejudiced. Therefore, this court should author a decision that cautions trial judges not to overuse the open the door doctrine. And there are some important considerations. Number one, has the door actually been opened by evidence? And we'll see this in particular in the second case this morning, but it's also present a little bit here. Number two, has the proponent of the counterproof been substantially prejudiced? You know, the kind that would prompt an objection by counsel the first time it's offered. Three, does the counterproof neatly fit the need that was made by the door opening evidence? And finally, does it satisfy Rule 403? Was the door opened here? Well, just barely. And I understand that the statement, we wasn't allowed to be around.
It was opened at all?
I'm not conceding. If it was just barely. And the reason for that is the third so-called incident, the one immediately preceding the prosecutor going to sidebar and saying, I believe the door has been opened, was to say, the defendant said, I am not supposed to, as in see my wife, contact my wife, making it clear that it wasn't the wife, trying not to use names, it was him.
You think that cleared everything up?
What was the everything to be cleared up? There was a statement that we weren't allowed to be close to one another, and then he said it's me.
I could understand why she was upset, which seems to suggest that she was the one who was not able to see him on their anniversary.
I think it was a fair inference to say that I messed up. I'm not allowed to be around here. Certainly in the context of saying...
Isn't part of your point it doesn't matter because what kind of order, who is prohibited from seeing who is not relevant in the true sense of the word, doesn't prove a fact of consequence?
Correct, it doesn't. And if there was some nature of confusion, I think it was cleared up by the statement, I am not permitted to see her. And that also touches on prejudice. I mean, that's really what we're talking about. The state didn't object. It could have. And that statement, again, right before the prosecutor went up the sidebar, I am not supposed to have contact with the wife, could have rectified any prejudice that may have accrued to the state at that point.
At that point, the state would get a cautionary instruction and sustaining objection.
Potentially, yeah.
And you're saying I don't know if this happened or not, but you're saying they thought, I could object, which means the judge will say, disregard that statement. But skunk's already in the jury box. It's not going to, but I could go ahead and actually get the actual fact of the matter into the evidence. I'm going to make a strategic decision to go with the second option.
Right. And I think
Is there something wrong with that?
Well, I think two things. We go back to how I started. The rules of evidence and procedure are there for a reason. And the rules of evidence primarily for reliable, non-prejudicial information. And the notion that attorneys must avail themselves of potential remedies is one this court has talked quite a bit about in the past 10 years. And for understandable reasons, why inject prejudice into a case where it doesn't need to be done? Stepping back to the grand scheme here, I've talked about.
So you're saying that you can never use the opening the door because you should always stand up and object and say prejudiced, and you have to be able to do that as a condition before then arguing later somehow opening the door?
The state courts of Maryland say that that is the case.
And that would be Maryland alone, wouldn't it?
It may be. I haven't done the research to do a 50 state survey on that, but I think there's a lot of sense to it. If the point of our rules of evidence is to have objections, to go to sidebar and to figure out what is proper evidence.
But it doesn't make sense to have the prosecutor required to object if the point is that it was what you're really saying is, gee, they're using it as an excuse to get in evidence they wanted to get in anyway. Why would they object?
Right. Well, that's another part. This wasn't evidence that was prejudicial to the prosecution. It was evidence that was, if at all, prejudicial to my client. The fact that we weren't allowed to be next to one another, that's going to imply some kind of nature of a restriction, a legal restriction. So going back to this idea of fit, what the state was allowed to then offer was that there was a court order prohibiting any contact. Those two things were not necessary. Now, I've already said I don't think they were necessary at all, but they weren't necessary even if we assume arguendo that some response was necessary to show that the
Your
condition...
position would be that the fact that there was a court order prohibiting him from having contact with her is simply not relevant evidence of anything.
Of anything. But if it was necessary to clean up something, and I don't think it was at this point, the court order part wasn't necessary. It was just we weren't allowed to be near one another. The any contact, rather than just on their anniversary, that wasn't necessary. It was 200%, whereas fit would be 100%, in other words.
I didn't follow the 200%.
It went beyond. It went beyond. It was double what was needed. The fact that a court order was mentioned and any contact rather than contact, just regarding the anniversary. Step 4 of the opening the door analysis is 403. 403 is still applicable. And we have a major problem with the 403 analysis here. The court inverted the proper analysis, finding that the probative value does not outweigh the prejudice in this case. We expect jurors to follow judges' instructions to a T. I think we should therefore extrapolate that what judges say is about legal standards is applied to a T, and that was what happened.
Rule 403 is kind of a mouthful. If we tried to spit it out rapid fire in the middle of when you're distracted from something else, I have to stop and think about it and see the words in my head. In context here, it's pretty obvious what the judge was doing, and the fact that it transposed the burdens. Isn't that clear from the record? Is that really a problem here?
Well, I think it was clear that the court was excluding, permitting the state to go into these questions. That's clear. Whether it did so applying the correct legal standard, the only evidence we have is it didn't. And also, we have evidence from the first trial where even the state admitted this kind of evidence with the court's tacit approval wasn't admissible.
Nobody asked the court to clarify. Said, Judge, did you mean that the probative value exceeds? And, oh, no. And never had the opportunity to correct it on the record. Everybody else seems to have assumed that it was the correct application of the actual language.
Or misheard. Correct. I have no way to refute that, I suppose. Although, if we're going to discredit, we're going to dock defense counsel for not saying, are you sure that that standard was right, for not objecting, in other words. I think we need to be wary of the fact that the prosecutor didn't object and ask for limiting instruction.
Absolutely, absolutely.
This was a sidebar discussion, correct? This wasn't before the jury. There was no danger of the jury mishearing or misinterpreting this, correct?
The objection and the discussion
Correct.
about whether or not it was be permitted. Correct. It was
It's
that
pretty
sidebar.
clear from the context, isn't it, that her actions, the judge's actions here, speak much more clearly than that one word.
Well, I think the judge's actions were clear that this was going to be permitted.
Correct.
According
So-
to the wrong legal standard. That's the only evidence we have.
The wrong legal standard, if you take that, if you assume that the judge was correctly speaking, I'm not sure the judge was there. I think it was an error, and it was an oversight. It was a misstatement.
Perhaps it was. We are at the fourth and final step of this grand schema that I've put out for the open the door standard. But judges, as this court says quite frequently, err. They use the wrong standard. Even when they know the wrong standard, they sometimes misapply it. And I don't think it is something that looks good to the public to have a judge who is saying the wrong standard, and the only indication we have applying the wrong standard, for that to be excused. And I think that case in South Carolina that I cited, it says as much. Thank you. I see the red light.
Thank you. Counsel, I note that you didn't reserve any time or protect any time, and the green light is on. What the defendant said was, I'm not, you didn't say anything to her. No, I'm not supposed to. You then wanted to put in, or the state wanted to put in evidence of the court order as to who was prohibited from having contact with whom. Why is that relevant? Why is it relevant as to whether he was prohibited from having contact with her, or she was prohibited from having contact with him, or just generally that there may have been something that prohibited him from having contact with each other?
So I think there's multiple things going on there. First, that there was that prior discussion on direct examination where he stated that we weren't allowed to be together.
Which was true.
Which is to some degree true, but I would argue that it's misleading. And so I think that the argument that perhaps...
So what if it is misleading, is my point. And then he, by the way, said, I'm not supposed to. So, how is it misleading? That is accurate, isn't it, that I'm not supposed to?
I suppose that part was not misleading, but it was bringing into evidence something that wasn't necessarily supposed to be in front of it, and that's in the context of them, of the defendant first saying we weren't allowed to be together, which wasn't accurate and was misleading.
So who cares? Why does it matter? What is it of consequence to?
I think it matters because it's not accurate, and
Okay, we say
the
things
state
all the
could-
time in cases that aren't accurate.
Well, obviously,
Sometimes intentionally.
well,
We're trying to understand whose story is correct, his or hers. And the initial Q&A was, she was very upset that day, and I could understand why. We wasn't supposed to be allowed with each other. So you could construe that as saying, ooh, she's not the one who's supposed to. She's upset. I better believe the other guy who's telling this story.
And that's exactly my point, Your Honor, is that it went to both. There was a potential chance, which is what Justice Lopez agreed with at the time, that there was a potential chance that they would be stuck with this impression that the named victim in this matter was the one who was subject to a court order.
And I'm still left with, so what?
So what? Exactly what Justice Connors said, that somehow that means that there was something else going on in the background that she had done wrong in some other part of her life or
And
something
why
of that
does that
sort.
matter?
I think it matters because there is a
The question is whether he did something wrong here.
Right.
Why should we believe her story as to what he was doing when she's prevented, there's some kind of order against her?
Exactly, Your Honor. And I think That's the point exactly, is that
But you didn't ask to put in evidence at that point. It was only when he said, I'm not supposed to have contact, that you asked to put in evidence.
Well, I think there's a cumulative effect here of multiple statements
But that was accurate.
about this issue of not being allowed to be there or being allowed to be there, and the jury is left confused to some degree. And so I think it was the state's position at the time that we wanted to clarify that confusion in as narrow of a way as we possibly could, which was we didn't get into why.
But you made it crystal clear that not only was there a court order in effect, but it prohibited him from contacting her, right?
Yes, and I think that was...
And a jury from that would understand. They have to understand. There is either a protection order, a bail condition, some kind of court order, because he did something wrong. How is that not incredibly prejudicial?
I don't believe that it is patently clear to a jury, which is exactly why the trial judge asked the state to narrow its questioning to try and reduce this in any way possible.
And so you said, isn't it true that you were the one who was subject to a court order prohibiting you from having contact with Ms. Taylor? It certainly wasn't Ms. Taylor who wasn't allowed to have contact with you, correct?
Yes, Your Honor, and I think if you look at what the trial court said at that sidebar discussion, I
understand the court ruled you could do that.
Well, so I suppose the reason why I asked that, why the state asked that question specifically, was it was directly in response to what the trial court had found to be the basis for the opening of the door.
But aren't you clearly telling the jury it was the defendant who did something wrong to occasion a court order?
I don't believe so, Your Honor. I don't believe that...
What is the interpretation the jury is supposed to take from that question? That it certainly wasn't her, it was you that was prohibited by court order.
It's clarifying the fact that when the defendant said we weren't allowed to be together...
I'm not supposed to have contact.
Right, so he said multiple things, there's no doubt about that, but the jury would be left with an inaccurate picture if they took the first statement to be the full or the correct, the initial version, whatever we want to use.
And you want them to know that it was the defendant who was prohibited, and that he's the one who did something wrong to occasion a court order.
Your Honor, I'm not going to agree that the reason for the questioning was to show that he had done something wrong previously. I think the question was asked...
Is there any other reason why there would be a court order in effect?
It's to alleviate the concern that the jury is left with the impression that she did something wrong.
Exactly, Your Honor. And the case law
and does it matter if the jury thought that she did something wrong?
As to the question of who may have been the aggressor in this situation?
I think that if that argument would have been made at trial, then perhaps it could have gone there. That wasn't really developed in the record there wasn't argument about, well, look, there was this prior court order, and so therefore he was the aggressor, right? I think that gets closer to saying that, look, he's done things wrong before, and that's why they can't have contact, and so he's done things wrong before, and so he's always going to do things wrong. That's not what happened in this case. And again, Justice Connors, I think, is making the point for me here that it was in response to the way in which the state's case was prejudiced, and that is
what was the prejudice to the state?
The prejudice to the state was the misleading statement that we weren't allowed to be together, exactly what Justice...
To say something that's misleading doesn't mean it's prejudicial to your case.
And it's because it goes to the credibility of the victim, potentially. And I think that the trial court did a good job of describing this, and I know you're not fighting me on whether or not the trial court was allowing this in. It was that they would be left with the false impression that a witness who the state had called was subject to any number of things that it could be, and that was inaccurate. And I think that's the bigger thing, is that it just wasn't accurate, and it would have been misleading to the jury if they would have had that thought in their head, which is exactly
If I heard Attorney McNamara correctly in his comment, I think I heard him saying, as a matter of policy, that counsel should not be able to sit on their hands when some evidence comes in that might be objected to and correct it right then and there, and then later on say the door is open to get something in. Was there anything in the statement that you could have objected to when the defendant testified to it? Could you have said objection, And what rule of evidence would you have cited in that situation?
Well, I suppose it could have been either relevance. I'm not exactly sure what the objection would be, other
Well,
than
I'm asking you whether you thought you did something wrong by not objecting it.
No, I don't believe that the state did anything wrong in that instance of not objecting, and I think that your point earlier when Attorney McNamara was arguing that the opening the door doctrine also acts as a deterrent to the parties to not try and skirt that line, to not try and go right up to the line, maybe just a little bit past it, because then, objection, strike, right? Strike from the record. The jury still heard it. And then the state's left with no remedy. The state can't clarify. The state can't bring in any evidence to say that, to clarify the record, to make the record accurate so the jury has an accurate
Is it okay
picture.
to do that? I mean, if, not this case, hypothetically, something comes in and it's objectionable, and counsel could object, and the judge would say sustained, members of the jury disregard that last answer. It's kind of a slap on the wrist with a ruler. Whereas if the party doesn't object, but it's open the door and you bring in the testimony to the contrary, that's more like a baseball bat. Is it a more effective trial strategy to sit on one's hands and come in later and have a much more effective shot to the other side's case?
I think that it may be more effective. I think regardless, that's not, you asked it in a hypothetical, so I think that the proper remedy for a party themselves bringing evidence which would otherwise be excluded is for the other party to be able to enter accurate evidence, relevant evidence, the exact type of evidence which the other party brought in. And just as you noted on Attorney McNamara's argument, it creates the deterrent effect that you can't put in evidence in a way that might benefit you and then not allow the state or the other party.
But in this case, the question didn't solicit that answer. I mean, I know that he gave it, but the question didn't directly solicit. So, I mean, deterrent effect is really not an issue here.
Well,
You have to agree with that.
I certainly agree that in this case,
It happens to both sides, right? Witnesses respond with something that, oh, that's not what I was asking.
absolutely. In this case, I have no doubt that the trial counsel for the defendant was in no way trying to skirt the line or push the limits in any way. But as a policy matter, I think that's a consideration moving forward. And so, yeah, I would agree with you that in this case, I don't think deterrence is necessarily applicable, but as a general policy matter.
We give a lot of wiggle room for the trial judge to make these determinations within their discretion, correct?
Absolutely.
So in this case, it sounded like the defense was kind of admitting that it was opening the door, saying his client was skirting the line as to opening the door. So if he's skirting the line and we give discretion, does that kind of mean under our standard of review it should be affirmed?
Certainly, I think it should be affirmed. I think under the standard of review that's applicable, it should be affirmed. I think that it is an acknowledgement by defense counsel that if it's not there already, it's right at the door, and I think that a trial judge absolutely has the authority to make that determination that, yes, it has crossed that line, and I think that's exactly what happened in this case.
Were you trial counsel here?
I was, Your Honor.
When the judge made the 403 ruling and apparently misstated the burdens, did that cause you any concern, or were you satisfied that you knew exactly what the judge was doing and what the test would be?
Yeah, I absolutely did not hear that when it was said. I think that we talk about 403 so regularly that you're just assuming that it went the way that you thought it would. Of course, in hindsight, I absolutely would have clarified that, but...
As a trial judge, I usually didn't try and recite the rule. I just say, under Rule 403, I'm going to do this.
And so I think that also gets to an important point that, again, the trial judge cites to 403, right? And so the trial judge certainly knows what 403 is. The entire sentence, I have considered the 403 issue. There is some prejudice to eliciting that testimony, but I don't find that the probative value substantially outweighs the risk of prejudice, given Mr. Taylor himself has opened the door to the issue. That full sentence indicates that it was a simple transposing of words. The context of all of this shows that the trial judge understood the Rule 403 and properly analyzed it under 403, happened to say the wrong words, but I don't think that those types of misspeaking are the types of mistakes that should cause this court to reject these convictions.
Well, isn't Attorney McNamara's point valid when you say it properly understood the standard and properly applied it? The words that came out were inconsistent with the proper application of that standard in the context of the decision that was made, wasn't it?
So I can say that I can take Attorney McNamara's point to some degree, and perhaps in a hypothetical case that isn't this one. The context of the entire description shows that the trial judge was applying the standard correctly. And so certainly it's not ideal that there was a misspeaking. But nonetheless, if there would have been more discussion clearly showing, or any discussion showing that the trial judge was actually misapplying this, then that would be much more concerning. But everything lines up to have been a properly applied legal test other than those two words being swapped.
And I think Attorney McNamara did cite a case where the trial judge elaborated on what he was doing there. It's like, no, that's not the way it works.
Exactly, Your Honor. And again, I think that the context of this shows it was a misspeaking and nothing more.
Thank you.
Thank you.
Just highlighting the fundamental irony here, which is, if I heard the prosecutor right, the reason that had to act to save the wife or the state from prejudice was because there was an implication that something else went on in the background. Well, what is the implication for defendant when we know that there's a court order? It's that he violated bail, that he was on bail for doing something violent. It's
Well,
the
let's go
propensity
back to the
inference.
first colloquy, and it's a hypo, so it's not this case,
Okay.
but let's say he said, she wasn't supposed to contact me. She wasn't. It was clearly wrong.
Right.
What's the prosecutor supposed to do at that point?
Well,
He can't object. That's what he said, right?
that's what he said, right. I think you, in that case, could remedy.
As somebody who taught evidence, the response is move to strike as opposed to
But
objection,
he's
sure.
allowed to say whatever he
Object.
wants to say,
Right, and then you would have the right to impeach him with other evidence, I suppose. In other
So
words,
at that point,
you don't have.
it's cross time for the prosecutor. Is the prosecutor allowed to say, I have this bail order here,
Yes.
and it says it's the other way around,
Yes.
doesn't it?
Yes. If
He's
it is
allowed to do
relevant
that,
evidence.
how are you prejudiced?
If it is relevant evidence, yes. But how is this relevant? Especially because we can't just take it and decontextualize it. After the third statement, I am not supposed to contact her.
So you're saying that clarified
That
things.
certainly clarified it, yeah. And
Was that within the discretion of the trial court to see in the context with the defense lawyer saying, well, it's skirting opening the door, to conclude, oh, everything's clear, so no?
I think you're missing part of what the defense counsel was saying. He's saying my client doesn't have the highest verbal acumen.
Correct.
And I understand why this objection is being made, why the state is up here. But read the rest of that objection. The state's own questioning is knocking pretty hard on that door. And if we get into my client was on bail regarding the alleged victim, the trial is over. And I think that those are the words. He's saying this is not a place we should go because it's super prejudicial, and that's what 403 comes down to. It is ultimately a balancing test. And the notion that we needed to save the wife from prejudice, well, it was defendant who was on trial for hurting his wife. And the public does not like domestic violence, rightly so. The public is primed right now to think that this court's, Maine court's judges have really lenient bail practices, whether right or wrong. But this was a credibility contest. And to infuse something that we know is prejudicial, because that's what Rule 404 is all about, into the equation, was just not reasonable considering, and I am with Justice Stanfield, Chief Justice Stanfield, there was no probative value after that was clarified. But certainly, if there was any, it was minuscule.
softball.
Thank you.
All right, thank you. Thank you, counsel. As is our usual practice, we will take this matter under advisement and issue a written decision in due course. With that, we'll be in recess on this matter. may be seated. And the matter before the court is Cumberland 24-530, State of Maine versus Daniel Cardona. And again, we're being streamed on the web, both audio and visual. If counsel would identify yourselves by saying your names for the record, together with the party you represent, since you're both back here again.
Thank you. Good morning again. Rory McNamara for the appellant Daniel Cardona.
Christopher Coleman for the state of Maine.
Thank you. And Attorney McNamara, if you're ready to proceed, we'd be happy to hear your argument this morning.
Morning. Attorney Coleman. So to recapitulate from where we were a few minutes ago, the standard, the schema as I have laid out for opening the door, was the door actually opened by evidence?
Well, let's skip to the chase, since we've talked about opening the door. And what if the evidence was admissible for another reason? Then you lose, right?
What if the evidence was admissible for?
If there need not be any opening the door.
Oh.
It was okay to let that evidence in the first place.
Yeah, I suppose. Well, part of the problem with that hypothetical here is that it was excluded for unfair surprise. So I don't know what nature of...
But is that a basis for exclusion under Rule 403?
Yes, it is. I think wasting time was the implicit part of
Well, unfair
that.
surprise is different than wasting time, isn't it?
Well, I think unfair surprise such that it would occasion a continuance for defense counsel to investigate what really happened, whether there were other witnesses it could
Well, let's assume we disagree that there was anything unfair about springing that evidence at this stage. And what if we also think it came in for other purposes in any event?
For other purposes in any event.
Without opening the door. In other words,
Without opening the door. I mean, it's theoretically, although it's interesting, Justice Cashman seemed to say, she said, and this is in the opening discussion about whether or not it would be admitted in lieu of the fact that it was late appearing on the radar. She said the case law goes both ways on this type of thing. So it wasn't clear at that point that in her discretion she would have admitted it for those other purposes. She excluded it initially for other reasons, and then the basis of her ruling admitting it is not, of course, for other reasons. It is to go to this notion of opening the door. So that's why I hesitate to answer questions about a different case, because what we have here is really kind of fact-dependent, and it is.
Well, but in that case, you know, when it was initially, no, I'm not going to let you in because of unfair surprise, there was a reservation of right to reconsider. If the issue is generated, then the state can reapproach, correct?
I'd like a caveat, but yes, with very specific non-hearsay evidence about chastity.
Well, I mean, and if there is a ruling by the court on an issue, either an motion in limine or an evidentiary ruling, and they say, well, this isn't written in stone, I can reconsider.
Right.
And if the court then reconsiders, then can we look on appeal? Well, it wasn't a surprise. I mean, she was a witness who was listed on the defense list, and the state's been trying to get this evidence in since day one.
Right.
So can't we kind of say, dismiss the original reason that, oh, unfair surprise? Isn't the court allowed to change its mind?
It didn't change its mind as to that initial ruling, that it was 403. It changed its mind because of opening the door. And again, we talked a little bit this morning about skirting a line and going right up to a line. It's actually very difficult from defense counsels, from prosecutors too, standpoint to know where the lines always are. And that's the problem in particular where you have a judge saying the door will be opened if evidence of the complaining witness's chastity is brought up. And chastity is something totally different than the theory that respectfully the prosecution argued opened the door. The defense counsel said something about a criminal record in his opening statement. That's not about chastity. Said something in two other instances that actually the state was the first party to introduce, as I've documented and happy to discuss.
You're talking about the being a foster home.
Being a foster home and also being a place where the cousins and the family and the children like to go to my client's and his wife's home. These were things that the state brought up, or the state asked to be brought up. So the problem here is that the basis for, if you will, if we're going to call it reconsideration, Justice Connors, is that it has nothing to do with the conditions that she said would permit reconsideration. It has nothing to do with chastity. And in fact, we know that she was hesitant to initially admit this, and she didn't admit it because of the 403 basis. So I don't think it's fair when we have an abuse of discretion standard normally for applying to evidentiary rulings to say that we should go, and decide that she was wrong to begin with, when I think it's certainly within her discretion to say under those circumstances this is not something that should have been admissible. The problem is with the legal analysis as to the opening the door. And I think some of that is the antecedent facts that simply are clearly erroneous on this record. It was the state that opened everything up. The legal aspect comes in with Donovan saying opening statements don't open the door to this kind of evidence. But then we do have, I'll acknowledge, other kinds of consideration that do, if they are properly considered, can be a matter of discretion. Was the state actually prejudiced by whatever it is that supposedly opened the door? And it's hard to follow exactly what that was. But again, here they didn't object. They made no request for any kind of instruction. They just went right for the jugular. And it's pretty plain from the record that that was something that they wanted to do because of the court's exclusion right from the beginning. And I respect counsel, but some of the arguments for how this door was opened are really, it's a ball of things that don't exist.
If we step off the opening the door issue for just a moment, as you know, the court, as you said, originally made a 403 ruling if the evidence doesn't come in. Is there any reason why a court, during the course of the trial, could decide later on that it does come in? Is the court forever bound by initial 403 ruling?
No, of course not. I think that there could have been if...
So in this instance here, I think it says somewhere that even defense counsel conceded that the testimony about the sex toy incident was somewhat relevant, and the court eventually reversed itself basically on that point.
Yeah, I think it could be somewhat relevant to the initial question. I don't think it's relevant to the opening the door pathway.
It isn't. I'm just saying,
Okay, all right.
if this is a separate pathway and it would get in anyway relating to the defendant's preoccupation with sexual matters and a focus on this particular victim, if that's going to come in anyway, or could come in anyway under that, do we need to worry about the opening the door avenue? Because this avenue is independent.
I get Your Honor's point. I think it's the same to where I was trying to go with Justice Connors, is that Justice Cashman at the beginning there said, well, I'm going to exclude it for 403 unfair surprise, which I think has to do with waste of time. But also, the case law is a little mixed as to whether or not I would admit this. And she didn't think at that point, with the defendant not putting on evidence, that it was something she was going to do. And really, it's difficult because how would the case have developed had defendant had the opportunity to vet that evidence and to look into it and prepare a strategy in advance of trial?
But if we concluded on appeal that this alternate avenue is valid, so even if the original theory, I think Justice Connor's question asked this, if the original theory didn't fly, but this alternative avenue for admission does fly, that we can affirm it on that basis.
No, I think you'd have to be saying that the initial exclusion was an abuse of discretion, and I just don't think that's possible on these facts, that you have a new, very relevant, very tied to the facts
Well,
of the
wait,
case.
can you back up for a second? You're saying that in order to affirm on an alternate ground, in other
Right.
words, that it could have come in anyway, we have to determine that the initial exclusion was an abuse of discretion?
Right, I think-
don't follow that.
I
I mean,
think
we're not
that's the
saying
case.
you should have admitted it, but if we were to follow through this idea that it could have come in anyway, it's really just on the harmless error analysis, isn't it?
Well, trial judges have discretion to make evidentiary rulings as long as they're using the correct body of law. She made an evidentiary ruling that is
Well,
certainly
she
not
did,
in
but I'm questioning whether we had to, don't we have to just say it could have come in anyway, therefore it is harmless, versus it should have come in, which is what you're saying, is that it was an abuse of discretion to have excluded it.
When you have something maybe presented, perhaps it had been just simply a 401 objection, basis of relevance, and you say, no, it really is relevant, I could see doing something like that. But where you have 403 that's prejudiced off of unfair surprise, off of the defendant needs a continuance, and in fact asked for a continuance that was denied before this is at the second stage.
Well, I think what you're saying is that the problem is because the defense relied on the court's initial ruling that I'm not going to let this in unless chastity comes into play, and your position is chastity did not come into play.
As to the opening the door doctrine, as to the doctrine of right for the wrong reason, I think we have to respect the fact that this was an unfair surprise, and that there's no abuse of discretion in the judge saying that. And in order for this
Well, but
court
the
to
judge
say,
also said, now if chastity is coming in, then I'm going to say it's coming in. So
Right.
you don't know, it's rock solid.
Right.
So if chastity comes into play, which is what she's finding, then all her weighing of the balance is she's saying, well, I told you it's not unfair surprise because the relevance has increased.
right, except that's not right for the wrong reason at that point. That is a question of opening the door, which this is a fundamental, there's nothing that opened the door.
So you're
There's
saying it's a
nothing
double level to make, that it's a matter of, it didn't open the door, so that wasn't an appropriate reason. And originally, it was excluded under 403 for unfair surprise. So in order to say it was right for the wrong reason, we'd have to find both of those
Right,
rulings
both
incorrect.
of those things. I don't think either one is true. I don't think you can just cut out the middle way and say we would have done something different, I guess is my point, because of that abuse of discretion standard. And I'll point out the state really hasn't made that argument either. If it had, I would have addressed it more fully in the briefing. There was a footnote I know about case law saying that 403 objections. This is from 1982, and I'm that old, and I sort of mean to
Preaching to
demean
the
it for being
choir.
that old, but I don't think it's ever been followed.
Okay, thank you. Attorney Coleman.
Good morning again, Madam Chief Justice and honorable justices of the Law Court. I appreciate the opportunity to address you for a few moments before this argument begins. Let me start with the last point. 403 gives us an exclusive list of reasons why things can be excluded by 403. That list is not an open list. Those are not for instances. An unfair surprise does not appear in Rule 403. Pettit v. Lizotte, which I did cite in my footnote, makes that clear. That case law might have been from the 80s, but like many things born in the 80s, it's still good. So I would suggest to you that absent something else, that case law should be followed by this court. Now, appellant complains of two perceived errors made by the trial court in this matter. First, he suggests it was reversible error to allow us to introduce the evidence of the sex toy. But I would suggest that State v. DeLong is pretty clear that relevant evidence is admissible, and again, as Justice Meade, I believe, pointed out, the trial counsel admitted that this was relevant evidence on the record. To show a relationship between the parties that in turn sheds lights on the defendant's motive, i.e. attraction to the victim, or intent, absence of mistake, opportunity, i.e. domination of the victim, to commit the crimes for which he was charged. Nothing could be more on point to the defendant's intent. This evidence went squarely to his motive. And that motive, it was now seen and shown through the evidence to co-occur with the specific intent necessary to commit this crime. The fact that this conduct occurred after the sexual assault, it's not a detriment. In the context of this case, it actually augments the probative power of the evidence. It's because we were also able to introduce significant evidence, not challenged here on appeal, showing that the appellant bore sexual attraction to and was grooming his victim prior to the sexual assault itself. That too was circumstantial evidence of his motive, which supported the specific intent necessary to commit this crime on the date of the offense. His attempts at grooming the victim and all of that evidence presented in conjunction with the complained of evidence shows that his motive endured after the sexual assault supports the inference that it spanned between the 2 points of time and thus co-occurred with the commission of the crime. That evidence, which is enormously probative of his specific intent, was available or ought to have been available to the state the whole time because the door was open to show the defendant's intent. We do believe and we maintain it was wrongfully excluded under 403 to start the trial, and we think the case law and very much the black letter of 403 support that. Second, I just want to talk briefly about the second assignment of error. I would just say that if this court accepts that no connection is needed between a statement which is supposedly being introduced for its effect on the listener, some showing that the listener actually heard that statement, this will become the rule which swallows the hearsay rule whole. Any statement could be introduced for its hypothetical
So I know that the green light is on.
Yes.
Going back to the first issue, are you agreeing essentially with Mr. McNamara that in order to affirm, we would have to find either that the door was indeed opened, or if we think that maybe the door wasn't actually opened by the statements about a foster home, that it would have come in anyway? Are you agreeing with him that we have to find the 403 ruling on the basis of unfair surprise wrong in order to say it would have come in anyway?
No, because there can be multiple reasons to exclude something and not exclude something. I think the 403 ruling is objectively an incorrect statement of law.
I was going to say, you're arguing that it is.
It is. But I don't think that that's a predicate for the state to bring in this other evidence. I also think, and I kind of agree with some of the onus of the questioning here, that the opening of the door is a bit of a red herring in this case, because the state's position is the door had been open all along for questions of intent, motive, these other things.
Well, okay, so go directly to the idea that it was, but the way it unfolded in this case, you argued to put it in, and the court allowed it in response to testimony about it being a safe home. And that testimony was really eliciting, as I read it, the mother's belief that it was appropriate to have her child go to the defendant's home because it was a safe home. I mean, it was a foster home. It doesn't go to that. I mean, whether or not he offered her a sex toy, her and her friend a sex toy, in a car, not even in the home, at some other occasion, really doesn't go to that, does it?
Well, again, I would look to the abuse of discretion standard that this court has said is appropriate. And it wasn't just that evidence. It was the fact that it was in conjunction with the other evidence, specifically the phone call introduced by trial counsel for the defendant that went all into the victim's sexual history, her sexual orientation, different people. So that's squarely to the first ruling by the trial justice.
That may be a bit more on point than whether or not.
I agree, and I think, opposing counsel had a very well-written brief. I concede the issue of the character evidence for the state and how it was introduced. But the door was open, and it remained open from the beginning in terms of motive and intent. And also, I would just note, I believe the record shows that at the time of the initial exclusion, she didn't just say the chastity language. She said, I believe there are a number of reasons it might come in. So with it being surprising to her that this evidence came at her doorstep the day of a trial, I think she needed some time to look at the case law. I think her comments reflect that. And I think by the time the third day of the trial rolled around, she had the proper legal reflection to make the order that she did.
Let me ask, relating to another issue that was brought up, about whether you can waive harmless error. And it's the defense counsel's position that the prosecutor can waive the argument of harmless error. But under the rules, we have to ignore anything that it doesn't affect substantial rights. So is the prosecutor able to waive a harmless error argument as to what standard of review we should apply?
If we find it to be error.
No, I mean, I think that's the court's prerogative to enforce the standard of review. I would disagree that there was error in this case.
Understood, but generically, if there is a conclusion that there's an error, do we always need to look at whether the prosecutor has waived or not waived that, because we're trying to figure out what our proper standard of review is, and the rule is telling us what our standard of review should be?
No, I mean, I think we have to follow the rule. I don't know that the prosecutor can waive.
That was my question.
Oh, well, I guess we're done here. There actually don't appear to be other
All right.
questions.
Well, lovely. Thank you all very much for this opportunity then. And with that, I'll sit down. Did it this morning.
Anything can be waived, right? If we can waive constitutional rights, certainly we can waive procedural rules written by the court. And I think that's contemplated. We waive procedural rules all the time. I want to go to this point that is really interesting to the court about whether Justice Cashman's initial ruling was correct. And I did have a chance to look a little bit at the case law from 1982. What we have to keep in mind here was there was a request for continuance by defense counsel. So the holding in Pettit, and in the case that I saw when I sat down here subsequent to it, it says there can't be a 403 exclusion based off of unfair surprise if there was no request by the defendant for continuance. Here we have a request for continuance denied by the court. That's on page 51 through 52, part of it of the appendix. And that's important. We just simply don't know, we haven't had the chance to vet the veracity of that information, to have an investigator go out to look at those kinds of things. And that's one of the reasons why I think Pettit ought to be redecided. Because
Well, let me ask you this, though. I mean, it happens, despite counsel's best efforts, it certainly happens that information comes to light on the eve of trial. In other words, information that truly wasn't in the state's file, okay? I mean, that happens.
it happens, although a big caveat, and this is something we're seeing a lot of these days, is pretrial investigations that happen, pretrial interviews that happen a week or two before trial for cases that have been sitting for years.
I understand that that's a problem, and that may be a different issue. But the point is that under our current rules, as they are, assuming that it really was not information that was indeed in the state's possession until then, and that seems to be the case here. I mean, it happens that victims say different things, witnesses say different things than expected, et cetera, add things that we didn't expect.
I do think that was why I'm not here arguing that there was a discovery violation. But I do think 403 is a catch-all for many things, and certainly one of them is waste of time. And if the prosecutor or the law enforcement should have done their investigation months ago to elicit that information, that's a waste of time. It's a waste of time that's very detrimental to the courts, and certainly to defendants, and to everybody. To have a continuance denied at trial for evidence you didn't know anything about, that's certainly within the court's prerogative. It was not an abuse of discretion to exclude it on those bases. There were, to respond to the prosecution's point, I've run out of time.
Go ahead, finish your sentence.
That there were a number of reasons why initially that was excluded. I think, how the prosecution could, defendant could open the door. I read her statement as saying there's only a very discreet way, non-hearsay, based off of her chastity. So Thank you.
Thank you, counsel, for the argument here this morning. And as you know, we will take the matter under advisement, issuing a written decision in due course. And with that, I think we're in order for the lunch recess until this afternoon.